Justice Gorsuch?
I'd like to focus for a moment on the statutory questions, one I raised earlier. I'd like your thoughts on it. We have both a constitutional claim but also a statutory claim, Title VI. And I understand our precedents have often conflated the two. But put that aside for the moment. Justice Stevens made a powerful argument in Bakke that whatever the 14th Amendment permits or does not permit, Title VI's language is plain and clear, just as Title VII is. And Title VII does not permit discrimination on the basis of sex, and Title VI does not permit discrimination on the basis of race. Can you help me with that?
Sure, Justice Gorsuch. So I think that the court in Bakke and Grutter correctly interpreted Title VI. The statute
where did Justice Stevens err?
In not recognizing that the term discrimination in this context is ambiguous. And I think that the legislative history therefore carries force in this context.
We didn't find it ambiguous in Bostock. Why should we find it ambiguous now?
Well, I think that the statute doesn't define.
Were we wrong in Bostock?
No, I'm not suggesting that. But Justice Gorsuch, I know you asked me to put to the side that the court has already resolved this issue. I just would emphasize
you're going
that
to go back to that.
We're talking about a statute here. Statutory stare decisis considerations have their greatest force. Congress has never overturned this court's interpretation of Title VI. Petitioners aren't asking this court to revisit its interpretation of Title VI.
On the text, though, do you have anything else?
I would point to the ambiguity in the term discrimination.
Okay. But it's not ambiguous in Title VII.
No, and we respect this court's decision in Bostock.
It's just ambiguous in Title VI, the same word.
This court has held that multiple times.
Okay. What do we say to Asian Americans who there's a veritable cottage industry, we're told by the briefs, that they are encouraging Asian applicants to avoid and beat, quote, Asian quotas. That's how they perceive it. Is that an important consideration? And that they tell applicants, coaches tell applicants to disguise their backgrounds and their names to the extent possible in order to secure what they view as an even footing in the admissions process?
I find those accounts appalling. They are not permitted under the Constitution. It's very clear that racial identity cannot be treated as a negative. That would be intentional discrimination. It's prohibited under equal protection. It's prohibited under Title VI, and Grutter does not countenance it. So to the extent that that is happening at any educational institution around this country, it's unlawful, and the university should be held accountable for it.
Thank you.